for all your mercies upon us. And we pray that you will grant us the strength with which to finish our task for this week. We look forward, O Lord, to the rest that will come over the weekend. And we pray that as we complete the rest of celebrations for Workers' Week, that we will look at the NITS bill with all the due consideration it needs. Thank you. In Jesus' name we pray. Amen.
Thank you, Minister Marcia Smith. We have an apology, you say, Secretary from Senator Albany. I think he's abroad, correct?
Yes, Minister.
Any other apologies?
No, sir.
All right. This morning, as I indicated, we're going to start out looking at the offenses. So we hope Jamaica can sort of put on the board those clauses that deal with offenses, so we can look and make recommendations as to the appropriate penalties for these offenses. And thereafter, we're going to go back to all the clauses and to consider those that we had not signed off on. So, Kamika, are you with us?
Yes, sir. Good morning. I am with you.
Wonderful. So, you want to tell us then the clauses that we have to consider for offenses, the present offenses, and any recommendation of the lead secretariat?
Very well, sir. So I'll share my screen.
Fine. You seem to be frozen. Right.
All right. So, sir, good morning. I'm so sorry. Good morning. All right. So as it relates to the offenses, there were several different, there was a theme running through for most of the offenses that they were not high enough for the persons who submitted. However, this particular offense, the one at clause 5.9, it states that a person commits an offense if the person willfully obstructs the authority in the performance of his functions and shall be liable on conviction, therefore, before a parish court to a fine not exceeding $3 million. And there were several individual, I'm going to switch between so you can have a better appreciation. So I'll just go to the actual. Oh, no, not for this one, right? We hadn't considered 5 in any event. So some persons who submitted did not know exactly what willful obstruction of the authority was. However, and so they had a concern with that. However, as you note, it states in the performance of its functions, and that's the qualifier. So the current penalties are, it's not triable in the Supreme Court. However, it is triable in the, parish court, and it's up to $3 million that a person may be fined. It's not, there is no imprisonment, and there will be no, and therefore also you can't, be fined and imprisoned. Let me write it this way instead.
What's the recommendation?
Right. So I looked at 2 other pieces of legislation. As you can see, well, labor officers are empowered to go and inspect, for instance. It's a pretty old piece of legislation. It hasn't been updated. So, but still, for the purposes of the imprisonment, we can look at that. So it's $100 or 3 months imprisonment at hard labor. The Tax Administration Act, any obstruction of their officers in performing those functions, $2 million or 9 months imprisonment. And as a result, the technical team does not recommend changing this fine.
So, colleagues, I think 3 million in the parish court seems to be quite adequate. It's higher than most of the bills or acts at the moment. So, if it is okay, we can basically accept the present 3 million fine for obstructing the NERA in the performance of their duties. If there are no objection, we'll move on.
All right, sir. The second major set of offenses were those with regard to the national databases. And under these,
Give us the clauses. The clauses.
oh, my apologies. You're not seeing, what are you seeing on the screen, sir?
No, go ahead. I am not seeing them. I'm a little distance away from the screen.
Oh, okay. All right. So it's 9.8 and 9.9 of the bill, and they mirror the Cybercrimes Act. And the offenses under the Cybercrimes Act are in part 2. So they mirror the clauses 5 and 6 of the Cybercrimes Act, which speak to, as here, accessing, unlawful accessing, modifying, intercepting, causing to be intercepted functions of the national databases. Yes, sir?
These fines seem to be quite high, but so we
No, sir, they're in line, because when you look at the Cybercrimes Act, they set out more comprehensive review, more comprehensive framework. However, that's because they speak to more than just protected computers. So if you may recall.
But you're not recommending changing them. It's 25 years or both fine and imprisonment.
Right.
So go ahead.
Just to say that I support the highest penalties, of including fine and confine, for any improper use of the information in the database.
No, I agree.
Because the protection of the right to privacy in an age where information is so readily accessible, it's going to be less about what you know, and more about how you use information that you know. And so this is a matter that has to be treated with the highest.
No, I absolutely agree, AG. And what I'm saying is that 25 years seems quite good. Okay.
Right.
So in the circuit courts, so it's up to 25 years, and the fine is unlimited. So it could be both fine and confine.
Right. Okay? And because it's a protected computer regime, it's only in the circuit court. However, for 9.9, we do have a fine in the parish court, and this is now accessing the database, degrading, causing failure of the national databases, interrupting, obstructing the operation, causing denial of access. If it is, we choose to keep the parish court regime, it is suggested that that remains at the 3 million.
Right, and here again, colleagues, this is consistent with 5 in that it's obstruction, but if the obstruction is really gross, then it can be dealt with in the circuit court at subsection 10A, which again is a term of imprisonment not exceeded 25 years, unlimited fine, and possible both fine and confine. So
sorry, if I may, there is one difference. There is a parish court jurisdiction here. So should we retain that?
But it is an alternative.
Okay, so should we insert it in the previous clause then? Because it's not inserted there.
I would say yes, because you may have a lesser example of how the offense is committed.
Okay. So, and that was the suggestion.
So in 10, then we're going to say a person who commits an offense under subsections 8 and 9.
Yes, sir.
So it's 8 and 9, okay? So
well,
excuse me, Chairman.
Yes.
I see Ms. Grant has her hand up, and then I also have my hand up. But Ms. Grant had her hand up much longer.
Go ahead, Ms. Grant.
Thank you, SG as well. I was just, according to my notes, also the issue was raised here about whether in the circuit court trial should be before a judge alone. So the committee might want to consider that as well.
Okay, a little late. No problem. Good enough.
Didn't we settle on that on the last occasion? My memory, just going by memory. That
I got a bit distracted a while ago.
That's my recollection to Senator Sinclair.
Yes,
Just
I'm
remember what-
sorry, you're correct. We did
Yes.
settle on that.
What was that CPC? I got a bit distracted a while ago.
Oh, I'm sorry, Chair, it was my mistake. We did set the issue of whether the matter should be before a judge alone. So that amendment will be made.
No, we agreed to that.
Yes, we did.
Right, okay, fine. Thanks again, CPC. So we're okay then with.
Sorry, Chair.
Yes,
So
yes, yes.
do you mind if I, thank you. My query though is that the parish court jurisdiction does not carry a custodial sentence. And is this the intention of the committee? Right now, it's just a fine.
Yeah,
It does seem a little curious if for the circuit court, you're going to put fine or imprisonment, but for the parish court, you don't have that option.
But it's-
Through you, Chairman. Thank you, SG. Good morning.
Right,
The regime would be consistent across. It would just be an allowance for trial in the parish court if the example of the offense is less egregious, and so the penalty within the jurisdiction of the parish court would
right.
punish on conviction.
Your AG, your connection is going in and out, but I think I got the general gist of what you said. SG, the idea here is that if the obstruction is really, as the AG I think was saying, is less egregious, I mean, it's not a serious obstruction, then it could be dealt with in the parish court because a fine is what is then contemplated. A confine, if a confine is being contemplated, then the prosecuting authority would take it to the circuit court.
Sorry, Chair, that's not my understanding of what the AG is saying. She's saying the regime should be the same in both courts, which would be fine or custodial.
Well, then we go back to clause 5. Remember in clause 5, we had only made it obstruction.
Right, but sometimes, right, but remember, it doesn't mean that it has to be the same in all clauses. But if you are thinking that this type of offense, even though it can be committed in a less egregious manner, but still, I don't think that is just the reason to say that you don't have the custodial element in the parish court.
I do have a difficulty, colleagues, by saying to a fine not exceeding $3 million or up to, what would be the suggested period, SG? Up to 1 year or 3 years? What's the usual consideration?
I think, Chairman, that probably CPC, SG, you can remind me. We've been standardizing in accordance with the monetary penalty. So it would
You keep breaking up.
It would be up to 3 years, Chairman.
Okay.
Right.
So we said $3 million or 3 years or both fine and confined. All right. So that is in subsection 10A, 910A. Okay, CPC?
Chair, is that the same also for,
No.
Sorry,
No.
both 8 and 10?
I would say so.
They appear, Chairman, where the provision is for fine and confinement. It would, and up to 3 million, it would be 3 years or both. Yes.
Right. So it's up to 3 million or 3 years or both fine and confined. Okay?
Yes, Chair.
All right, wonderful. Go ahead now, Kamika.
All right, the next offense that was noted is in the enrollment section, and this speaks to someone who provides a false statement or well, there's several offenses created there. The first one is where someone provides false information or makes a false statement of a material nature with the intention of obstructing or misleading the authority in several different scenarios when they're providing the information to enroll, making a confirmation of the content, making a modification to an entry, or obtaining the reissue or issue of the national identification card. That particular offense had been an issue for several persons who submitted, because they were of the opinion that it may serve to criminalize persons just on this basis for providing false information or making a false statement. However, the technical team is of the opinion that it must be something of a material nature, and the intention to obstruct or mislead the authority would have to be present. Consequently, it is necessary. The other legislation that was looked at was the Registration, Births and Deaths Act at Section 64, which speaks to omission of or failure to give information, and that jurisdiction is a parish court up to $1 million. The Forgery Act also has somewhat of a similar offense, where anyone who making by any person of a statement which is to his knowledge untrue for the purpose of procuring a passport, in this instance, whether for himself or any other person, and that's imprisonment up to 2 years. The team would suggest that the penalty, or lack of penalty rather, in the Supreme Court, that is that it's not tribal in the Supreme Court, remain, and at the parish court, the fine would be up to $3 million. As it relates to imprisonment, it could be up to 2 years, we believe.
No, but except for consistency, Kamiko.
Oh, for the 3 years.
Right, so we'll be looking then at clause 10. Is it 10.7?
10.7A.
10.7E, where it is provided for.
Oh, you mean, right, yes.
Well, the fine governs all of those.
Right.
Okay. Right, that's the point. So what is being suggested then is that it's been 3 years or both fine and confined. Is that so, Kamika?
Right, in the parish court, but sure,
right.
the only...
And we would leave it in the parish court.
Right.
So is that okay, AG, SG, and members of the committee? We're just going to add or 3 years or both fine and confined, consistent with the other provisions. Okay.
Sorry, Chairman, might I just ask a question, please?
Sure.
If I recall correctly, part of the issue with this was if errors were made. It was about the offense itself. And I wondered whether there is any adjustment that has been agreed in that regard, because I think although the language says that it provides false information or makes a false statement of a material nature with the intention of obstructing or misleading, as opposed to an unintentional error. And I'm not sure how, the practicality of that type of interpretation or its application. But I think that members of the public who have raised the issue were concerned that if they just made an error or with no ill intent, for example, I believe an example was given with an address that wouldn't be considered their principal address, but it's somewhere where they stay. So that type of circumstance where it could be considered false information. I think they were just concerned that the scope would capture them unintentionally.
But Senator Johnson, if you look at subsection 8, it provides that it has to be basically intentional or reckless. If you want to remove reckless, fine.
Yeah.
But subsection 8 specifically says that the person knew or believed the information to be false. Now, where could be ambiguous, or was reckless as to the veracity of the information. So if you would like to restrict it to that intentional position of 8A, though, that's quite restrictive. What do you think, Senator Johnson Smith? Are you seeing subsection 8A? Senator Johnson Smith, are you with us?
I am, sorry, Minister. I was just saying that I know that I've missed a few meetings, so I wondered whether that issue had been addressed in a way that made them more comfortable.
No, actually.
I'm aware.
No, actually, Senator Johnson-Smith, we're not recommitting the clauses yet. We are going to come back to clause 10. What we are now looking at is just the offenses.
Okay, but I know that the two were linked, so they were concerned about being captured and then that being defined. So the question would be if there were either an adjustment to the offense or a subcategorization that moves it out, or something that addresses unintentional errors. I don't know. Anyway,
so what
I don't want to delay the discussion.
No, but it's a very important point. So to the extent CPC, that if a person unintentionally, provides information that turns out to be false, could we have a defense at all, CPC, in that section, if a person unintentionally gives information which, maybe at the time believes it was good? I'm not saying it's not captured in 8 at the moment, subsection 8. But what
Chairman, could I just, could I make an intervention?
Sure, Member Robinson.
Who makes the determination about what is unintentional versus intentional?
In a sense, it's the court. At the end of the day, it's a court if the person is being charged.
Before you get to being charged, who would make, for something to get to the, would there have to be a referral, or would there be a determination at the level of the NID Secretariat, whoever is managing, about what is intentional or not, and what would they be guided by?
Well, this is the point. You see, what we're saying, Member Robinson, is that.
May I come in, Minister?
Go ahead, AG.
Right. So the scenario could include some issue arising as to the accuracy of the information provided, which has some consequences with respect of the use of the identification card. It would really, and whether it would turn on any set of facts where an issue arises in relation to any critical aspect of the information to be supplied to enable the unique identification of the holder of the NIC in question.
But you see,
what I want to guard against is the potential for where there is discretion for it to be abused, in the sense that someone may be charged for something when they really wasn't intentional. So I just want to minimize as much as possible that discretion.
You see, that's the point, Member Robinson, in that you see, and the concern of many contributors was that many people may give information believing them to be correct, but it turns out to be incorrect. Now, there's no doubt that they would have to be, as you quite rightly say, they may well be charged, and they may well have the thing to court to say, I never intended it. When I gave it, I believe it to be true. You see the point? So one of the things that we're asking now is whether we could put a sort of, in a sense, make it explicit that if the person gave inaccurate information, believing the information to be true, you get me? Then they should not be charged.
So, Chairman,
yes.
It's clear that it's not a strict liability offense.
Fine.
It is not. Then the two core ingredients of an offense would have to be made out: the actus reus and the mens rea.
No, I accept that. I accept that.
And so the wording of it makes it clear that it would require some intention on the part of some willfulness.
But AG,
the person supplying the information.
AG, not everybody thinks like a lawyer, you know.
Pardon me.
I mean, when the ordinary man reads this.
But judges do, Chairman. Judges are trained.
No, I accept that, AG. But what we're trying to say.
What we're trying to find is if there's a way for them not to go before the judge, not to have to be charged up front for something that was on. If there is language that can allow for that greater clarity.
In other
Because
words,
you don't want to have somebody have a criminal charge for something like this.
exactly.
It can affect them in so many other ways in their life.
Right.
So-
So the offense is important, and it's important that the penalty be sufficiently that it disincentivize the provision of false information, but we just don't want it to unintentionally cast too wide a net that would allow for persons to have to defend themselves then. That's really the concern.
Minister Johnson Smith, I think that puts it well. So
yes, that's the point. That's
Sorry.
the point. You see. So the
Mr.
question
Chairman.
there, yes, Senator Sinclair.
If looking at the provision which is being discussed here, which is subsection 7, and I suspect everybody is focusing on 7A. That seems to be the one that is, because B says fraudulently, which obviously requires some intent, well, not some intent, it requires intent, knowingly in C. And then you have the catchphrase, which is contained in subsection 8. The one that doesn't seem to specifically refer to it, though, is A. And I don't know if adding the word knowingly or some other word that specifies the requirement of an intent. And then you have the other qualifying words contained in A. Material nature. Well, it actually says with intention. So
Well, that's the point.
yeah. So
Sorry,
I
excuse me.
think all the provisions makes it clear that there is requirement for knowledge.
Well, let me just
Sorry,
say,
excuse me, Chair. CPC
Yes,
has been trying to intervene, and I also have my hand up because
unfortunately,
I
I just put on your lovely video, and then I will know you want to speak, because sometimes I don't see here that your hands are up. So if you want anyone who would like to speak that I'm not recognizing, just put on your video so I can see. So go ahead, SG.
well,
Good.
it's just that CPC had her hand up before, but I think we should look at 10.8. 10.8 says, for the purpose of subsection 7, and subsection 7 lists out it lists the offenses. So for the purpose of that offense creating provision, an individual provides false information if at the time of the provision of the information, the individual A knew or believed the information to be false, or B was reckless as to the veracity of the information.
No,
Doesn't that address the issue?
there's no doubt, SG, that it addresses the issue for all legal minds. The question to the common man, suppose I inadvertently gives incorrect information, do I have to pay $3 million? And you see,
But you would not have knew or believed the information to be false, so you would
I
not have met 8A. You would not have met that
yes,
standard in
I
8A.
accept that, SG, but we have to bear in mind that to the ordinary person, the ordinary man, the non-legal mind, they want it to be clear that if they inadvertently gives inaccurate information, they won't be charged.
Mr. Chairman,
Yes.
but this clause of charge that provides for a charge, it is not the individual that is going to determine whether he's charged or not. It will be the investigating arm of the state. And it is they who must appreciate that they should not impose a charge if the person, based on their investigation,
But
they investigate and charge.
that is what Member Robbins is trying to avoid, Senator Sinclair.
But
He doesn't want the person to be harassed, put it that way.
Mr.
You know, what the
So-
person should be able to say, when I said my address was A, and it turned out when you investigate it is B, that person should say, well, I was there, I lived there 10 years ago.
But Mr. Chairman, it is, even if the person puts that forward to the investigating arm of the state that is going to charge, that does not prevent him from being charged.
No, but to the extent that the person can say, when I did it, I didn't realize that I could not give my previous address.
Chairman.
Yes, yes, sir. Yes.
I would also like to remind that it is for the prosecution to prove these matters. So the prosecution must be able to make this case. I don't see where there is anything there in terms of the intent to be proved that is unclear. And I'm concerned that if you attempt then to, for want of a better phrase, dumb down the provision, it is going to be a provision that is not legally tight.
Well, the issue there that I would, if you look at the subsection 8B, the question of reckless, should we keep that so that it becomes almost, you know, a knowledge-based, that the person knows definitely that he's giving false information.
Chairman, may I make a contribution here? I think it is very important that we actually omit B, because that is where I think the mischief would be done. And it covers the scenario which has been outlined, that, for example, where somebody gives an address, which subsequently has changed and so on, and can give the explanation that at the time I lived there, or at the time I had no fixed place of abode, so I gave my sister's place or so. So the recklessness, I think, is where the person would be more endangered by the offense. I agree with what has been said in regard to the knowledge, the other section, because I do believe that the prosecution will have a duty to prove it, and that a defense can be raised if they can get beyond the bar. So the prosecution would have to be in possession of material information, which would make them proceed with a charge.
So what I would agree with you, and that is what I'm proposing, that we remove subsection B. So it would just read that the information that the individual knew or believed the information to be false.
Absolutely, sir. Absolutely, Chair. That is very important.
Which is consistent with the language of previously, because everything is speaking about new or knowingly gives in fraudulently obtains.
Yes.
So
that is a clear requirement for mens rea, whereas the recklessness does not, to me, meet that standard, sir.
Right. So is that agreed? I'm proposing that, colleagues, can we agree to remove subclause 8B? Any objection? Are there no objections? So CPC?
All right. That is for the removal of B, Mr. Chairman.
Right.
No, I agree with the comments made by Senator Scott Martin.
Right. So CPC and Jamaica, we're going to remove subclause 8B and make it very clear that the individual in giving the information will only be prosecuted if they knowingly and definitely gives false information and know the information to be false. Okay? All right. And the next one, Kamika, the next.
All right. Yes, sir, you're not hearing me?
No, we're hearing you now.
Okay, all right. With regard, the next offense would be those created under clause 11, and those speak to where a person commits an offense if without lawful authorization the person collects identity information from an individual. The constitution of the offense itself had raised some concerns, as persons were of the opinion that it may creep into other areas of
collected
Well,
information.
right, of wherever information is being collected. And the response had been that it was contextual to this particular clause. Right, and as it relates to that, we had the technical team looked at the Lotto scamming, the Law Reform Fraudulent Transaction Special Provisions Act, which speaks to knowingly obtaining, processing, and distributing identity information. And the offense there is where a person commits an offense where that person knowingly obtains, in our instance, identity information of any other person in circumstances, so it goes further than ours, in circumstances which give rise to a reasonable inference that the information has been used or is intended to be used to commit an offense under this act or any other law.
So you don't see the need to, you don't see the need to change the present position. At the moment, you have a fine not exceeding $2 million.
Right. And we would be, the team would be okay with retaining it if there is no change to the formulation. However, we do bring to the attention of the committee this particular concern and ask that we look again at that formulation to see whether or not it could be modified to read, because of the issues which had been raised, perhaps it may be necessary to put in some further information so that the person doesn't only collect information, but collects it for a particular purpose. So that is also being brought to the committee's attention.
So, no, okay, so the penalty is not being affected. It is the formulation.
Right, for this one, yes.
Well, could you note first, Kamika, that when we come back to recommit clause 11, we make that change, since we're only now dealing with the penalties.
The offenses. Well, okay, all right, sir.
All right, go ahead now.
All right, and as it relates to, right. The next one would be clause 14.7, cancellation of enrollment, where the individual who cancels enrollment is given notice that their enrollment has been canceled. They mustn't use the NIN anymore, and they must surrender to the authority within 30 days after receiving the notification, the national identification card that they were issued. And anyone who, without reasonable excuse, continues to use the NIN or doesn't surrender the card within the requisite period, commits an offense. And this offense would be one to which clause 28 of the bill applies, because it doesn't indicate a particular penalty. And clause 28 indicates that it's a fine in the parish court up to $1 million. Right. It's not triable in the Supreme Court, and there is no imprisonment within the parish.
So the problem, okay, so we're looking at 14.7 commits an offense, right?
Right, yes.
And then that offense is dealt with in clause 28.
The penalty is dealt with in clause
28. So that is a penalty, that is one of the penalties which other section deal with other offenses being dealt with in section 28? Apart from 14.7, which are the other ones?
1610.
Would be?
No, not 1610, not 1610, sir.
1611. No, what 1610 and 11? No, 1611.
1612.
Oh, 1612. So where it says commits an offense without a penalty, they're dealt with in section 28.
28,
so
right.
Both, all right, so both 14.7 and 16.12 should be, CPC should be commits an offense. How do we refer back that the penalties in section 28?
Section 28 is already phrased to for that purpose, Chairman.
So here is 28.
Because it refers to the commission of offense for which no specific penalty is provided.
Okay.
So because no specific penalties provided in those two provisions, 28 would apply by virtue of that reference.
Senator Sinclair.
I would just want to ask, Mr. Chairman, why are we drafting in that particular style? Why not just put the penalty where the offense is committed instead of placing it in a standalone?
So let me just ask Ms. Kamika, are those the only two areas where commits an offense? Any other one?
24.
20 section 4?
Right, yes.
Any other?
No, those are the only ones that I am recalling.
So Senator Sinclair's position, CPC, could we just put the penalty up to 1 million and punishable with a fine up to $1 million in those?
Chair,
Yes.
I think we should also pause to contemplate the penalty which we are imposing. For example, at 1611, if a person, knowing that the card is a counterfeit national identification card, if the person willfully takes possession of it, knowing it is counterfeit, it is to a fine not exceeding $500,000.
No, that will be
These penalties. Pardon me, sir?
No, we're going to be coming back to that.
Yeah, but the reason why I'm raising it at this time is to look at the severity of the offenses and to contrast that with the one which we are presently contemplating, to determine whether in fact it is appropriate to be imposing a fine of $1 million for something that I consider not as significant an offense, not as great a breach as taking possession of a counterfeit card. So you forget to remind them or whatever, you forget to turn it in, which is the one that we are considering now. The 30 days, because we were raising several.
14.7, it's on the screen.
14.7. So you have not surrendered within 30 days after the notification, and you're going to be fined $1 million. Whereas if you have, you understand the point that I'm making?
No, I understand the point very well.
Okay.
So what Senator Scott Motley is saying is that the inconsistency, if I might put it that way, between 1611 and 1612, for example, why is there that inconsistency? In other words, Senator Scott Motley is saying, if you go to 500,000 in 1611, why are we going to $1 million in 12 when it appears that 1611 is probably as egregious as 12?
Or worse than
worse.
Or worse.
More egregious, more egregious.
So is there, Ms. Faison, what can we?
No, we are in agreement with Senator Scott Motley that would definitely have to be addressed.
So what we're really saying is that the real problem there is the 500,000, if I might say that. Senator
In that,
Scott. Would you say we should, the 500,000 Senator Scott Motley should really be $1 million? What do you think?
I am saying that I would turn them around and make the greater fine be for knowingly being in possession of a counterfeit card, and the others which are really, more acts of omission in that way, rather than acts of commission. I would make it 500,000, but that is only my opinion.
No, well, Senator Scott Motley, turn on your camera when you're speaking, please, if you don't mind. I think you see what Senator Scott, your audio is on. What Senator Scott Motley is alerting us to, and I somehow agree with her, we must be very careful how we impose, severe penalties on persons who may just be punished for an omission.
Yes,
You
that's
see,
the point I'm making.
Right. In other words, we can understand where persons who deliberately or intentionally do something that the penalty should be high. But where there is what could be an omission or a failure to do something, then the penalty should not be as great, because it might well be just carelessness on their part.
And I'm sure Senator Sinclair is going to support me in this one, Chair.
100%, Senator Scott. And you know, when you look at them, you know, because in 12, what you would be imposing a penalty for of $1 million is where the person would have lost their card, whether, you know, and did not notify the authority. But then the others, their card is stolen, their card becomes damaged, mutilated, or destroyed, and they did not report it. But then they also can suffer another penalty, for want of a better word, because they may not be able to conduct their business efficiently without having a card. So it would be a burden on them to want to report it.
So you would want Section 28 then, Senators Scott Motley and Sinclair, the 500,000.
In relation.
Or we can move, you know, 1611 up to 10 and make it consistent $1 million.
You mean 12? It may be a little more than that to my mind, because if a person knowingly takes possession.
You're breaking up, Senator Sinclair. I'm freezing. I think it's awesome.
Chair, if I may,
are you hearing?
No, you broke up a while ago, Senator Sinclair. Just repeat.
Okay, no, I was just saying if a person knowingly.
You're breaking up.
Counterfeit, and I don't know what is probably my, let me see.
I think what Senator Sinclair is, the point he's making is that if a person knowingly takes possession of a counterfeit card,
right,
knowingly, that is really a significant.
Well, that is why I was suggesting Senator Scott Martin, we move that up to $1 million and leave the other ones at $1 million.
I don't think an act of omission, sir, respectfully, deserves that kind of onerous penalty.
Well, bear in mind, you know,
although we have to think about even what we are doing to the justice system, because if I travel, if I am away, or I've asked somebody to turn it in for me because of circumstances beyond my control or so,
right,
is that is an omission. I mean, there are all sorts of explanations for that, for omissions.
No, but
and I just don't think that we should approach this, use the same standard as with holding on to a counterfeit card, which we know really shows that criminal intent. No, that's the point I'm making. But I stand to be guided by the person.
No, I accept what you're saying. Save and accept. Bear in mind, $1 million is not a fixed penalty. It is a maximum penalty. So that.
Yeah, but it does serve as a guide for to the judges, sir.
So what's your suggestion? Reduce it to $1 million?
I am saying that for those acts of commission, perhaps of omission, perhaps we should consider reducing them to the 500 and keeping the counterfeit, for example, putting it at $1 million. That's what I'm suggesting.
So, and then you say Senator Sinclair agrees with you. And any other comments from other members of the committee, Senator Johnson Smith and AG?
I agree with the approach, Chairman. Thank you.
Yes, Chairman, I have no difficulty with what is suggested.
So we're going to reverse those penalties then. For knowingly keeping a counterfeit, we put up to $1 million. That is in 1611. And for the others, in section 28, we change it from the $1 million to 500,000. Okay? All right. Go ahead.
The other concern that I had in respect to even if we did that change, if a person knowingly takes possession of and retains a counterfeit card, it is clear that that person has some criminal intent. And what is the difference of that as against a person who provides false information with the hope of getting a card which in effect may be counterfeit?
All right, I think the point is made then. So thanks again, colleagues. Any other areas, Kamika?
Just to be clear, just to be clear, Chairman. All right, so cancellation of enrollment, we'll be moving that down to 500.
Right.
And with regard to taking possession of or retaining, we'll be moving that up to 3 million.
No, 1 million. That's 1611.
All right, but Senator Sinclair just indicated, if through you, Chair, could Senator Sinclair reiterate what he said earlier? Because my understanding was that he was equating it to 10.7,
Yes.
which is 3 million.
Right.
So
right. And 3 years.
So I was looking at a situation, if a person knowingly takes possession and retains, why are we even with the turnaround that we spoke about? I think for that breach or that offense, the penalty should be a bit higher than even the $1 million.
So I don't have a difficulty moving it to 3 million, Senator Sinclair, if other members agree, because it's knowledge showing that they have a false, that they're doing something which is wrong. And knowledge is required in that clause. So I don't have a difficulty instead of the 500,000, 1611, moving it to 3 million, okay?
And in 12, we would be
500,000.
500,000.
Right, because those are omission, failure to act.
And the other issue that I had, Mr. Chairman, and I don't know if we have used that style of drafting because we have not, in respect to what we are being told, is just 3 sections.
Right.
Not stated the penalty in the section itself. We have put it in a standalone clause in 20, is it 28?
Yes.
Yes.
And I was just asking, why did we adopt that style in dealing with it, and not just put it in the section itself?
Chair, I was attempting to answer that question earlier.
Yes, sorry.
Yes, so this is the style that's adopted, and it's a signaling, because these are the offenses that are set out there in that residual offense provision in clause 28 are the lower end of the scale offenses, and they are drafted that way so that we keep them consistent to avoid the problem that Senator Scott Motley alluded to, where you might end up having disproportionate penalties for these lower scale offenses. So the intention in having them in that one provision is to keep them all together so that they attract the same penalty.
All right, so it's a drafting style, Senator Sinclair. AG, you wanted to comment? AG, you keep coming in and out. Okay, we're not hearing from AG.
Chair, if I could just...
Sorry, Chairman, no, I wasn't trying to come in, but I was having a problem unmuting the mic.
Okay, thanks, okay. Yes,
Chair,
Ms. Stacey.
Right, as it relates to section 28 as well, just to point out that it's also, the offender may also be dealt with community service orders.
Right, so it is possible alternative. All right, any other section, Ms. Stacey?
So 1610, this now we may need to, well, we will have, this is with where the person willfully tampers with the national identification card. Given that we have increased the others to 3 million, it may be appropriate to increase this one as well from 1 million.
I agree. Any objection to that, colleagues? This is where the person willfully does something.
No objection.
Right. But 2 million or 3 million?
3 million. We go to 3 million.
Okay, and the 3 years?
No, just the 5.
Okay, okay. All right. So we've dealt with 1611 and we've dealt with 1612. Right. Now this is 17.2, where someone uses a national identification card to impersonate an enrolled individual, or permits or induces another person to use a national identification card to impersonate an enrolled individual. And currently it's a fine of up to 3 million, which seems to be consistent with what we have been agreeing thus far. However, with this one, perhaps the 3 years should be inserted here. That was our
Well,
suggestion.
if we're going to insert the 3 years, then we would have to make it, put something to say intentionally. You get me? In other words,
Okay, yes.
so I would leave it as a 3 million without the confine, because, you know, this looks like one that could be committed recklessly.
Yes, yes, okay.
I would leave it at the 3 million without the confine, okay?
Very well, Chair, thank you. The content of the national identification card, this speaks to manufacturing, producing, printing, binding, designing, distributing a document that's purporting to be a national identification card. Currently, it's a fine not exceeding $3 million or imprisonment for a term not exceeding 3 years.
I would add our both fine and confine.
Okay, all right, sir.
I mean, those are appropriate. Or to
Yes.
put fine and confine.
And keep it at the parish court level.
Right.
20 part 4 is where the individual has their card has been canceled and they haven't surrendered the card within 30 days of receiving the notification. And we had gone down to 500.
Right, the 28-4. 28, clause 28.
Okay, so we are keeping clause 28 and
Right.
all right. Okay, sir. And those were all of the offenses.
All right, so colleagues, unless there are any issues raised, what we want to say is that we have looked at the offenses under the Act and the corresponding penalties. Sorry, Camila.
Yes, sir. Okay. There was one other offense where well, a suggested offense by Jets. No, I'm so sorry, sir. How could we forget this one, or how could I? Clause 30, the secrecy and confidentiality clause.
Oh, yes.
Right. Now, currently, this only goes up to $3 million in the parish court, and it's only a fine. Yesterday, the SG had indicated to us several other pieces of legislation, so that, and the Tax Administration Act, it's $1 million or 12 months or both in the parish court. Integrity Commission, similar. And the data protection, it's $2 million and or 2 years imprisonment. And it's suggested, well, currently it's at 3 million. Given the concerns of the public,
we should put our 3 years or both fine and confine.
Right.
So our 3 years or both fine and confine. Okay.
In the note as well, though, sir, that in the Data Protection Act, the Circuit Court, it's fine and imprisonment up to 10 years. And it was therefore suggested, because of this particular gravity that persons clearly ascribe to this particular offense, we insert the Circuit Court jurisdiction.
Right. So if colleagues have no objection, we will not only increase the penalty in the parish court to 3 years, or both fine and confined, and the circuit court up to a maximum of 10 years, or both fine and confined. Is that agreed? Consistent with the Data Protection Act, and also to protect the confidentiality of the information that is obtained or dealt with by the NERA. Is that agreed?
Supported, Chairman.
All right, so we have dealt with offenses, and just to reiterate, we have increased for most offenses the penalties to demonstrate that we want to ensure that the NERA is protected, and especially where persons like the Commissioner of Police gets information and anyone has to deal with it. If they fail to keep the confidentiality, then we have increased the penalty to more than 3 million, or also the possibility of a term of imprisonment. And that hopefully will ensure that persons who are enrolled feels confident that their various information data will be adequately protected. Now, moving on from there, Kamika, there are a number of clauses that we have to recommit. apart from 5, 6, and 26 and 27, which we will be dealing with next week when we do the governance structure. And just to indicate, colleagues, that the NIDS team and myself are in discussion with the Electoral Commission of Jamaica, and we will be able early next week to indicate the ECJ will play a very important role in the governance structure. But we want to sign off by, hopefully by tomorrow, Warren. And so by next week, we'll be able to indicate how the ECJ will play a very important role in the NERA. Having said that, Kamika, can we now go back from the beginning and let us know which clauses give some difficulties, and if the NIDS team have cleared up as we go along. So, okay, so colleagues who are here.
Chairman,
Yes, AG.
may I just ask that we just have a reservation on the finalizing the objectives, the objects of the act. I think it's clause 3.
That is number 3.
Yes.
My son, can you see it on the screen? AG, can you see it?
Just ask for a further deferral of it.
No problem. So clause 3 will be further deferred, okay? 2, what was pending? Can we,
Right.
can that?
When I indicated pending, sir, those are the ones that we have not yet discussed because they're for a later meeting.
All right. So, and 3 will be further deferred as requested by AG. 4.
4, sir, we have not finished receiving the policy implications that we were asked to look into, and we asked that that be deferred as well because we were to obtain some information from Ministry of National Security.
No problem. And 5 and 6 will be deferred too,
Right.
pending. Okay, so move up.
Right. This was to be recommitted when we were 7, when we were considering the governance structure, and
So both 5,
8,
6, and 7.
right. And 8, Senator Scott Motley had reserved their comments as it related to the cooperation between the authority and public bodies and asked that we come back to it. So
Senator Scott Motley, you ready, or you want it further deferred?
If you will just permit me to speak to it on the next meeting so that I can remind myself of my reservations.
Okay, no problem. Okay. All right, continue.
The national databases, there were a few submissions that were not considered, so we could go to that, to those, sir. If
This is section number 9.
Number 9, right.
All right, could you remind us to see if we can sign off on 9?
Very well, Chairman. Okay. All right. One of the, yes, Chair?
Yes. Go
Right.
ahead.
So one of those was actually with regard to an offense and whether or not one should be included within this bill. And 876 Solutions and the Lawyers Christian Fellowship, pardon me, made submissions regarding the meaning of lawful authority. And 876 Solutions actually wanted to, or suggested, well, no, they queried rather, whether an offense was created where someone with lawful authority accessed a database when they don't have any need to access the database. And the response at that time was that the offense would fall within the purview of the Cybercrimes Act. That remains the response from the technical team, unless it is that the committee wishes to insert a specific offense here, but the technical team would not advise that that route be taken.
Chairman?
Yes, AG.
Again, given the understandable nervousness around this issue and the privacy, the right to privacy, I believe that it is sufficiently egregious if someone were to unauthorizedly access the database in respect of the NERA. So my view is that an offense should also be created here and not just left to the cyber crimes law.
So,
Because of the kind of information that is contained or to be contained in these databases.
so your suggestion is that that particular section, clause 9, should provide for an offense where.
That's my perspective. That's my view on the matter.
And CPC is not dealt with anywhere else in the Act? What is being suggested here, CPC?
Sorry, Chair, I had lost part of what Ms. Spacey had explained about what the concern was. Is it their concern that there might not be an offense for somebody who lawfully accesses a database?
Right, and then proceeds to either view information or that they don't really have any need to be in the database at the time and they're still within the database.
Right, but what would have been the wrongful act there? That they're just viewing something they're not supposed to view?
Right, or just the fact that they're in the database when they don't need to be in the database. That was our understanding of it.
In other words, a hacker or someone who
No, sir. It would be someone who does have lawful authority, but at the time they're right. So at the time they're in their in the database, though they should not. They have no reason to be in the database.
I'm not quite sure what would have been wrongful act there without them having done more.
Anything.
Because if they have lawful access to it, they have lawful access. Where it goes from there is if they then use that lawful access to commit a crime, which I think is already covered under these provisions.
I agree with you, Madam CPC. It's not the mere access of it. If you have access to it, you are accessing it for the purpose that you're required to do, because it's my understanding that there will be different levels of access. So that if you access it, but you're not authorized, or you're not accessing it for a lawful purpose, then it would be in that realm. But if it is already covered, so be it.
No, but that's the point, AG. You see, if you access if you look at 9, 8, and 9, you speak without lawful authority, and therefore penalties imposed if you access the database without lawful authority.
So two things, even where you have access to it, if you use it in an unauthorized or unlawfully, that should be treated quite punitively.
Well, that's the point of CPC. What CPC, the AG and the complaint is that if you have lawful authority but misuse it, then it should be the same penalty. So
yes, but Chair, it's covered there because the provisions in 8 and 9 are disjunctive. So 8A covers lawful access unlawfully, B covers any unlawful modification, C covers any unlawful interception, and so on. So even if the access may have been lawful, if you unlawfully modify, then you would be caught by B.
But I think part of the issue, Chair, if I might, was the possibility that a person has lawful access, so they therefore use that access. But they do not anything that is provable. They don't actually modify the data, but they might do something you're unable to prove, like take screenshots of it externally to use it otherwise. The fact is that all you would be able to prove was that they accessed the database. You would already know that they have the lawful authority there to do this, but you wouldn't be able to prove the action that they took otherwise. And the point, I think, from the tech perspective, their concern is that persons have ways to remove their footprints, I suppose. And that if once you have lawful access, then you can pretty much, outside of what is provable here under B and C,
no,
then
the real issue though, would section 30 cover, those situations?
But Chair, that scenario that was just outlined by Minister Johnson Smith would be captured by 8C as well, because that would be an interception, and interception is defined there as meaning listening to or viewing by use of technical means, or B, recording a function of any program or data in the database.
No, but what they're saying, those CPCs, for those persons who unlawfully, what they're really saying is that persons who lawfully have access to the data where they misuse it. You see, both
Yes, Chair.
You see, what they're saying is that 8 and 9 deal with only with persons who without lawful authority.
Yes, Chair, and without lawful authority is captured in 8, because 8C would read a person commits an offense if the person without lawful authority willfully intercepts or caused to be
Yes, but
intercepted.
they're saying if they have lawful authority to access.
Yes.
Then if they have lawful authority to access, are you saying that you would say that any act of interception, as you have defined it, would then become unlawful?
No, the scenario that was outlined suggested that the person might have had lawful access, but then they go ahead and capture a screenshot of something or on the database and use it for something else. So I'm suggesting that although the access would be lawful and therefore not captured within 8A, the unlawful act, which is the taking the screenshot and using it for something else, would be captured by 8C.
Okay.
Chairman.
Yes.
Yes, may I just make a quick comment here.
Yeah.
Based on how the system is being designed, if an authorized officer should have maybe access a profile, the owner of the data will be notified. And based on the framework, the owner of the data may choose to report that incident, want to figure out why are you browsing my data without any reason at all.
But but Warren, how would that enrolled individuals know? In other words, the point that both agents and we're contemplating is where the person, yes, works with the NERA, has lawful authority, but misuses the information.
So this is where we need to have a strong framework, because you're going to have audit trails all the way for everything in the authority. So I believe what we are saying here is that you really don't want an officer that is authorized, meaning based on the permission assigned to you, you go in and browse the database as you feel like, and there's no reason behind it. And I think that is what we're trying to resolve, and that is what most persons are concerned about. How do you put a framework in place to ensure that the people who are authorized, the people who have legal access to the system, that they only use it for what to deliver services? Yeah.
But Warren, and that's the concern of JET and the committee members. What happens if they vary and do use it for unlawful purposes?
If I may, Chair, the response, the offense that we had referred to as falling within the purview of the Cybercrimes Act was the offense at section 4, which is where a person commits an offense if that person accesses any program or data held in a computer with the intent to commit any offense punishable by imprisonment for a term that exceeds 1 year, or facilitates the commission of an offense referred to, whether by himself or another person, whether or not they can actually access. And for the purposes of this section, it's immaterial whether the access is with or without authorization, and whether or not the access is secured or at any other time.
Well, what the AG was suggesting, if I recall, is that that particular section should be made clear in the NERA. Rather than going to this, that's what you were saying, rather than going to the cybercrime, could we put it as a section in 9?
May I just further clarify, Chairman, that it would be futile for us to make a conduct an offense where it cannot be proved, however suspicious we may be, because the legal standard is different from, the court of public opinion, and mere suspicion is not enough to find guilt. But I do believe that for ease of use of a legislation, while cross-referencing is not a bad thing, ease of reference, sometimes it's better to put matters in the bill where the conduct relates to that, unless, in the overall scheme of things, you just utilize the other piece of legislation.
All right, could we,
But
CPC
I think more than anything else, it's a signal that would be sent that the databases, the integrity of the databases must be maintained, and all persons who will be authorized to access them must understand that there are rights that are engaged, and those rights can only be infringed in accordance with a high standard and very set principles of law.
right, so CPC, what is being suggested is that what was read by Ms. Facey in the Cybercrimes Act, is there any way we could put it in section 9?
But Chair, I'm wondering why, because if it's covered under cyber crimes, which is the regime which deals with offenses of that type, why is there a need to duplicate the same offense in this bill? The same concern would apply to any other piece of legislation which deals with the custody of information kept in electronic form. Are we then to duplicate the offense in the Cybercrimes Act in each of those, in each piece of legislation?
What the AG's position is that out of an abundance of caution and to make it crystal clear that to anyone reading this act, that they would see that if in fact persons with lawful authority to the database, if they, in any circumstances, should misuse it, then it is a penalty.
Sure, Chairman, I won't be insistent on the point. The intervention of the CPC is taken, the discussion had begun at a higher level. But what is to be clear is a signal that has to be sent unequivocally in relation to how matters are to be treated.
Okay. All right. You see, so about it, please, members of the NITSE. Warren, I think the AG has a very good point, just as she put it, the signal that you send in terms of the protection, the further protection of enrolled individuals' data. Okay? All right. So that is the main concern, Kamika, in the section 9, right?
Yes, Chair. Basically, it was around the phrase lawful authority, what exactly it meant and how it could be utilized. The clauses, the other consideration was that clause 9, 7, and 9.8 didn't, 9.7, 9.8, and 9.6 were not working together. However, the technical team, right, Mona Law queried the interaction as they appeared incongruous. On one hand, the information within the national databases may be altered, and on the other hand, when you alter it, an offense is created. However, I believe that may have been a misreading because the actions taken at clause 9.7 would have been as a result of the request made for alteration at clause 9.6. And so those actions would not have been undertaken without lawful authority and wouldn't constitute an offense under 9.8. And that was the response with regard to that particular concern.
You don't really see the need to modify anything?
No.
Right.
No, we don't believe.
All right, which was the other one now? 10, it's 10.
Right. With regard to 10, the committee may recall that though there is a framework already inserted for persons who are not able to apply on their behalf, on their own behalf, whether they are in, well, due to a mental disorder or because they are within a detention area of whatever sort, well, let me not say detention, in a correctional institution, or the person has a mental disorder or is a child. Those instances are stated within the bill. However, it was pointed out that persons, for instance, who are infirm, it may need to be more specifically stated in the bill that these persons, that applications may also be made on behalf of these persons. And additionally, we may need to look through the bill and ensure that in all instances, practically, the applicant can continue to act on the behalf of the individual and not only at the point of enrollment, but wherever necessary.
Is that being discussed with the CPC in terms of clarity of the draft?
We had one discussion, but I don't believe we had concluded. CPC? And I don't think we had finished speaking on that. So you want to...
Yes, but I don't see that it's a clarity of draft issue. It's more a policy issue of who is to be accommodated here. And then I had the reservation about the treatment of infirm persons within this context, because really here what we're seeking to cover is persons who are not mentally competent to make a decision about submitting an application and the details thereof. Physically infirm persons, not including some type of mental disorder, they do have the capacity. It's just a matter of not being able to physically deliver the document. So I don't see this provision as needing to cover them. And the regulations dealing with how the manner in which an application is submitted could have provisions which would facilitate ease of access for persons who have other disabilities.
So the sort of, the sort of policy direction intent can be dealt with in the regulations. Is that so, Ms. Stacey and CPC?
Yes.
The regulations would take care of the concerns.
Yes, we are guided by the CPC, yes.
All right, thanks. Okay, let's see if we can finish up 11 then. I think there were some concerns, it's either 10 or 11 with refugee status. I think Warren, you could help us there. Where persons, you recall, I think it's 11, Warren, where the question of persons who Senator Graham had brought up that point. Do you recall?
Yes, Chairman. Kamika has the information and can share.
All right, go ahead, then, Kamika.
Right. With regard, it was really the eligibility with regard to persons who were not necessarily ordinarily resident, as well as with regard to enrollment, the identity information being provided. All right. With regard to eligibility, sir, we had wanted to obtain all the information before coming back to the committee, because though we have spoken with one area of the government with regard to refugee persons who are asylum seekers, we wanted to just ascertain some more information. So from another area of the government. So if we could recommit this.
That's 11.
Right, just so we come with comprehensive information.
All right. I think that's basically where we're going to stop this morning. Sorry, go ahead.
Sorry, I do have some information as it relates to refugee status. From the perspective of the chambers, we don't think that someone who, because you see, when someone makes an application for refugee status, the whole process is treaty-based. Asylum occurs at the end of the process.
Okay.
So, and that can take up to sometimes a few years.
But would you give them an ID?
So we don't think that during that process that they should have the card, because they may not be granted refugee status. They may not be granted asylum.
All right, but SG, this is still a matter that the NITS team needs some further clarity to return to us with. Okay, Ms. Stacey?
Yes, sir, will do. All
right, could you just scroll and let us see exactly which other clauses that are pending from 12 onwards?
Right.
So 12 is concluded, 13 concluded, 14 to be recommitted, 15 concluded. Go ahead.
Right, so
But
most of
we're
them
dealt
were,
with 16, and then, no, 1 second. We've dealt with 16 in terms of the offenses.
right, yes, so we have now
And
concluded.
17 can be concluded. 18, all right, 18 still to be done.
Right,
So
and
19, continue. 20 concluded, go ahead. And basically,
right,
26, 27. So, team, I think basically, there are a few more clauses to be examined. I'm going to sit, and then next week we want to deal with most of those clauses, but I'm going to suggest we don't meet on Tuesday, the day after Labor Day. So we meet next week, Wednesday, and from what I'm seeing, there's a real likelihood that we could conclude next week, Wednesday and Thursday, because the governance structure, which would cover not only the schedules, but also some of the clauses from, and just indicating the likelihood is that they will be settled for a presentation to be made as to the governance structure next week in one or two sessions. So it's at 10 o'clock, and as I always say, we will conclude exactly at 10 o'clock. So I'm asking for motion of adjournment.
So moved.
Thank you very much, and seconded. Thanks, everyone. And next Wednesday, we won't meet on Tuesday. We will meet next week, Wednesday at 8:30. Thanks again, everybody.
thank you, Chair.
We work to make community